Professor Jack Mwimali is the CEO of CLE and also an advocate of the High Court of Kenya. Thank you very much for honoring our invite. We are really honored and blessed to have you here with us. I'd also like to recognize our Dean, School of Law, Dr. Martin Owor. Thank you very much for your continued support and your assistance in making this day happen. We also have our very able and strong advisory board members who comprise of Ms. Carol Musau. Thank you very much. She gives us wise counsel, matters business and corporate affairs. We also have Dr. Nyamboga present and also Professor KK Kivuda Kibwana. He's absent, but he sent his apologies. He could not be able to join us this afternoon. I am made aware that Dr. Nyamboga won't be joining us this afternoon, but we are expecting to have him. He's also part of the advisory board. We also have the faculty, Daystar University and faculty School of Law, and all invited dignitaries and the vibrant community of law students. We have MKU, we have Kenyatta University, African Nazarene, UMA, and our very own Daystar. So with those many acknowledgements, I'd like to welcome you all to this very momentous occasion. It's not just an occasion or a celebration, it's with you guys being here, I think it recognizes that each one of us has the passion to transform law, and that law is not only what we have in our four corners of the lecture halls or what we have in the courtrooms, but law is what we uphold in our day-to-day lives. Law is what we live, and it's what transforms the society. In layman's, without law, would be a very lawless society. So thank you very much for joining us. And I'd also like to extend gratitude for everyone who made this day happen. Thank you very much to acknowledge the advisory board. You've worked tirelessly with us. Asanteni sana. You've helped us bring this idea to life since we started thinking about it months ago. We really appreciate you, and thank you for your continued dedication to make the verdict known and be out there. At this juncture, I'd like to welcome our Dean, School of Law, who will officially invite the guest speaker this afternoon. Asanteni sana, karibu to Daystar. Let us give him a round of applause as he comes to the stage.
Our guests this afternoon, our keynote speaker, Elisha Ongoya, Mwalimu. His fame precedes him. We have Professor Jack Mwimali. He is the CEO of the Council of Legal Education. That is the body which regulates legal training in Kenya. And as a School of Law, we are licensed by Council of Legal Education. That is why you can confidently pursue law at Daystar School of Law without any fear. We also have Kokore Mwalimu Omondi from UMA University with us here. Of course, we have our colleagues from Daystar School of Law, Dr. Martin Olo, he's Associate Dean of the School of Law. We also have HOD Private Law, Dr. Benjamin Masau. Okay. We have with us also the youngest lecturer at the school. This is Emmanuel Tioko Ekiru with us here. We also have Madam Carol Musau, also a member of staff at the school. we are also happy to have her here. Now, allow me to also then recognize our students who are here from the School of Law, and I also am aware there are other students from other law schools here, and specifically Kenyatta University. Any other school? Uma is with us here. African Nazarene, and Mount Kenya. So we welcome all those schools to Daystar University, and specifically to the School of Law. Now, allow me to, and my name is Maurice Ajwang Owuor, Dean School of Law. Allow me to congratulate the Verdict team under the leadership of Collines Muyeku and Chebet for a very innovative idea. This idea is revolutionary because it brings together law students to brainstorm, to share views, to share experiences, to have a fora where they are able to debate on current legal issues, and also to be good citizens. And being a law student particularly places a slightly heavier burden on your shoulder because you are expected to have a slightly keener sense of the law, and you are aware of the maxim ignorantia juris neminem excusat. The ignorance of the law is not an excuse, okay? So therefore, as law students, you must have a good command of the law. And it also means that among students in any institution, you have a greater role to play because you appreciate the laws of the land, you appreciate international laws, and therefore you are able to basically advise or even share with other students on issues affecting your country. And I think for you, with the recent happenings in the country, the Gen Z demonstrations, as law students, you must then be able to appreciate the Constitution. You must be able to insist that every person has the right to associate. You have the right to express yourself. You have, all these fundamental rights and freedoms, and therefore encourage others as well to exercise these rights without feeling, without being apologetic. So therefore, I congratulate the Verdict for this, for its launch and for this very innovative idea. Also, allow me to also state that the topic of this public lecture is very appropriate. The state of legal education and its future in Kenya. As law students, you must be interested in the state of legal education, because it is the state of legal education which shapes you. It determines what kind of a lawyer you become. It determines, the kind of law students who are, law students who come out of that legal system. And therefore, it is a topic which is appropriate. And very quickly, I would just want to share my thoughts on this particular topic and say that there are several factors which influence legal education. And among them is the education system. The education system can assist education, and in this particular case, legal education, by having a curriculum which is structured in such a manner that the learners are, the learners appreciate the value of reading and the value of writing. And maybe that is a deficiency in our legal system, in our education system, where there is that apprehension that our learners may not really be reading as much and writing as much. There is also the other worry, and this also has the possibility of affecting education, and this is the value system. Increasingly in families, and they say the family is the basic unit of a society, increasingly in families we see a breakdown of values. And therefore, and this maybe is also influenced by the nature of the modern world, where parents are so busy that they have very little time to impart values to their children. And therefore, children or young people develop without, that value system, and that also influences the kind of law student, the kind of lawyer, the kind of advocate that emerges from our education system. And I would also want to think that the role models that young people have may, in some instances, not really, contribute towards their development. But I'm happy that Mwalimu Elisha Ongoya is a role model of young people, and he's a good role model. He's a good role model because he is, he is a teacher of law, of repute. He is an advocate of the High Court, and I think you are familiar with his courtroom presentations, okay? And I think what strikes me most was, I think, when he was, I think it was in the National Assembly, and he was saying that, was it Senate? And he was saying that man is to error, but this kind of error, okay? This is not the kind of error which is, which one should be pardoned for, okay? We would wish to see many more role models in the mold of Elisha Ongoya, because he's a good role model. He's a good role model. The other thing I would wish to share briefly is that legal education is also influenced by curricula. Legal education is influenced by curricula. And you will find that every school has a law curriculum, and every school has a niche area. For example, the Daystar School of Law has a niche area of media and communications law. So therefore, that niche area is supposed to distinguish the Daystar law program from other law programs. And therefore, the curriculum review or the curricular review, which institutions, the opportunity to review curriculum from time to time, is also an opportunity to shape legal education. It's an opportunity to ensure that we have legal education which is relevant to the young people, that young people are able to benefit from the curricula that we have. Let me talk about management of institutions. The manner in which institutions are managed also influence the direction which legal education takes. And I would want to concur. Previously, I think in the course of the day, we were discussing with Mwalimu Ongoya, and he seemed to agree with me that the management of a university determines the future and the state of legal education. And we were able to concur that Kabarak University, through the Vice Chancellor, has developed a law school which is worth admiring. And similarly, we could also say that through our own Vice Chancellor, Professor Ayiro, the School of Law at Daystar increasingly is becoming unnoticed, increasingly is becoming a school of choice, okay? And therefore, management is important in terms of shaping the education system, and particularly the legal, the education in relation to law. Now, I also would want to acknowledge the role of regulators, and today we have CLE with us, and we also know that we also have Q. All these regulators ensure that law schools maintain certain standards, that law schools are institutions which ensure that learners come out of law schools with with a good quality of education, and therefore will be useful in terms of transforming society. Finally, as I come to an end, I would also want to say that the state of legal education in Kenya has also been influenced by some of the challenges that we see at the Kenya School of Law. And those challenges are contributed partially because of the numbers. The numbers at the Kenya School of Law have increased manifold. When I joined the Kenya School of Law in the year 2000, which is recently, we only had one shift, okay? But as we speak today, because of numbers, you have a morning shift, you have an afternoon shift, you have online. So therefore, these are challenges which also influence legal education. And for that reason, there is a move towards the decentralization of the advocates training program. Meaning that going forward, it will be possible for you to pursue your advocates training program within your own institution. So that if you are in MKU, after your bachelor's, instead of going to the Kenya School of Law, you will have the ATP program in your university, but of course it will be regulated by Council of Legal Education. And the examination will be an examination which is set by Council as well. But again, that is part of the responses to the challenges affecting the Kenya School of Law. And with those very many remarks, allow me to bring my remarks to an end, and again to appreciate all of you for turning up today. I believe that at the end of this public lecture, you will be wiser, you will be much more informed, and you will therefore, see the importance of, being involved in issues relating to legal education and the future of legal education. Thank you very much, and I would now take this opportunity to invite Counsel Mwalimu Elisha Ongoya And let us welcome him with a round of applause. Karibu mwalimu.
Thank you so much, Dean, and thank you so much, everyone present. I want to ride on the protocols already established and delve directly into my agenda for this evening, seeing that the weather is taking control of its own fate, perhaps the way we should all do. I was invited to have a conversation on the state and the future of the legal profession in Kenya on this occasion of the official launch of the verdict. My name, as you've been told, is Elisha Ongoya. I teach and I practice the law. On 28th of January 2022, Chief Justice Emeritus Professor Willie Munyuoki Mutunga delivered an inaugural lecture at the Kabarak University School of Law. The title of the inaugural lecture was In Search and Defense of Radical Legal Education, a Personal Footnote. In his oration on that day, Professor Mutunga included a postscript in that lecture entitled Kabarak and its role in the search and defense of radical legal education. Speaking for myself, I'm always inspired by the piercing challenge that was set out in that postscript. And therefore, for full effect, I'll reproduce for you here that postscript extensively. He wrote, and I quote, Professor Hirji, the Tanzanian revolutionary intellectual, urges us to see radical legal education as part of our struggle to counter under-education within the struggles to counter underdevelopment. These are struggles to build a society that is free, just, peaceful, gender just, non-sexist, non-ethnic, non-racist, non-militarist, ecologically safe, equitable, and a prosperous socialist society. Radical legal education is anchored upon unfettered academic freedom. Both the state and the university leadership must uphold, protect, and defend academic freedom in teaching, research, and writing. Academic freedom is also about resisting any attempts to subvert the academy by any interests, whether internal or external. Academic freedom births the battle of ideas in the academy, a fundamental reason why universities exist. Whatever the merits and demerits of this debate, one issue is clear. Education is the mother of all rights. Educational institutions are nurseries for the status quo as they are for the resistance of the status quo. I believe every law school in this country has to take a position on the issue of radical legal education. The position will be identified in the various approaches I have reflected upon in this inaugural lecture. Let us now turn to Kabarak. Will Kabarak be a beacon for this search and defense of radical legal education? Will it carve out its own niche as such a beacon? Will Kabarak be the Dar, meaning the Jerusalem Law School, of the 1970s in its innovative, democratic, and creative methods? Will it be the Nairobi before the reversal? Will it continue the vision that Makerere supports? Will it follow Makerere by establishing another gender institute on the African continent and also a center for human rights and social justice that are both committed to radical legal education? Will it value interdisciplinary and multidisciplinary approaches in legal education? Will law students at Kabarak be exposed in their studies to national and global struggles to create a better planet? Will their academic and political freedoms be upheld, respected, and protected while at Kabarak? Will the contestation of ideas happen? Will Kabarak reflect intellectual leadership or intellectual hegemony? Will the law students and staff value collective intellect? Will the respect for academic freedom reign? Will Kabarak ensure that these changes take root and prosper and that there are no reversals? In a nutshell, there are struggles going forward that need answers. I doubt if these questions and inquiries are new at Kabarak. Let the debates continue. Let the battle of ideas continue. Let the search and defense of radical education in Kenya and the world, and indeed at Kabarak, continue. I am persuaded myself that the challenges raised by Professor Mutunga in this challenge, or in this postscript, apply to my audience today, just as it applied to the community that was the primary target of that lecture at Kabarak University on that date in January 2022. So allow me to pose some challenge to you, my audience in this hall. What is your view of the legal profession? You need to show your respect for this profession to others. Your entire conduct in the legal profession will show how you view it. There is need for you to put back into the legal profession. And you start by putting back now, from the very beginning. The best preparation in the legal profession is there from the very beginning. Those of us who are litigation lawyers know this very well. An honest submission in the legal profession is there from the very beginning. One day, you'll become seniors. I'm talking to those of you who are my students here. When you become seniors, you'll move very close to power and money. These two will bring pressure. I beseech you to ensure that when that happens, let the honest submission weigh heavier than the pressure of power and the pressure of money. In a nutshell, at every point in time in your presence in this profession, examine your concept of the profession itself. If you consider that there are important ideals in this profession that protect the country, that bring justice to people's lives, can you protect those ideals if your conduct itself is sloppy? I beseech you to have good habits and good manners in your entire professional engagements. Allow me to then reflect on what I regard as our profession at crossroads. Let me point out, I do not know whether this is the challenge of our profession alone. But because I interact with people from all professions, this is a fear that all professions are grappling with. I teach law in the university. And sometimes I encounter students who show less than seriousness in their conduct. I also encounter a critical mass of students who are very serious in their conduct. For those who show less than serious conduct, I challenge them by the following questions. Number one, do they believe that there are people studying to be surgeons who are also showing less than serious conduct? What will they do when they fall sick and while on the surgeon's table, the less than serious surgeon is in charge of their operation? Will they be confident? I also ask them a question. Do they also believe that there are students in the School of Aviation who are less than serious. What will they do when, while 36,000 feet above sea level, they discover that the person in charge of the flight is not serious after all? And I challenge them, and I challenge you, if that will bother them, then it must also bother them in their capacity as lawyers if they are less than serious. Why? Because as lawyers, we are responsible for people's lives, people's limbs, people's liberties, and people's property. And these are critical aspects of people's lives. There was a time when being a lawyer in Kenya meant you are a custodian of the conscience of society. Lawyers were the voice that spoke when power grew arrogant. Lawyers were the translator between law and justice. They were the defenders of the weak. I have the privilege of interacting with young people by virtue of my role as a teacher. And therefore I can say I meet young lawyers and law students virtually every day of my life. If you doubted it, you know I'm meeting you today. And therefore, you are an answer to that challenge. When I encounter young lawyers and law students, oftentimes I hear stories not of a calling, but of bare survival. I meet law firms who seek my intervention to recommend young graduates from the law school where I teach for internships and pupillage. When I listen to the attributes being sought for, I get the impression that we are hiring marketers before we hire researchers. I mean, I meet graduates who have capacity to recite historic cases, but lack capacity to navigate modern contracts. And therefore I ask the question, what has become of the legal profession in Kenya? Can we, in good conscience, in all honesty, assert, without fear of contradiction, that we are still a profession of honor? Or have we become a trade, a hustle? Are we shaping justice, or are we merely serving briefs? As you sit in this hall today as a law student, do you have the impression that you are being processed into a thinker, or you are emerging into a technician, a spanner boy of sorts? Now, I'm not reading a eulogy in the burial of the legal profession. I am providing a mirror. I'm inviting all of us, students, practitioners, scholars, and regulators, to re-look at our profession with honesty and to reimagine its future with courage. So I reflect on the following related questions. Number one, what is the true state of the legal profession in Kenya today? Number two, what are the forces shaping and reshaping the legal profession globally and locally? Number three, how have we allowed training, research, and practice to become disjointed islands? Number four, what will it take to revolutionize legal education so that it meets the market needs and societal needs simultaneously? And number five, what kind of lawyers must the future demand of us? On my reflection on the legal profession, I wonder, are we experiencing growth with direction or growth without direction? Let me assert a true and unequivocal fact. For Kenya, the legal profession has never been larger than what it is today since God created earth. Law faculties have multiplied across the country. For your information, when I joined law school, there were only 2 law schools in this country, the University of Nairobi and Moi University. Today, I wonder whether I have an accurate count of the numbers. Because on occasions when I assert the number, I get told, no, that college in Westlands also became a university and has a law school. I suspect that we have a number ranging between 20 and 25 of law schools in Kenya at the moment. The membership of the Law Society of Kenya has crossed 20,000 advocates. And yet, between 1902 and 2005, when I was called to the bar, we were 5,965, which represents my own admission number. A period of more than a century. 20 years after that, we have multiplied that number 4 times, notwithstanding that advocates are dying at a faster rate than ever before. This growth is important because this growth confirms that a country is developing, a country that is having more educational institutions, a country that's having more professionals is a developing country. Yet, sometimes I am pained by the reality that we may be experiencing a case of more lawyers with less justice. Despite this growth, meaningful employment and professional fulfillment are far from guaranteed. Thousands of graduates emerge each year. Many are underemployed and are drifting into unrelated sectors. Many are lawyers who are now selling skincare products. What is worse for me is not the underemployed and those drifting into unrelated sectors. What is worrying for me are those that are unemployable. That even if the opportunities came, you will not in good conscience employ them. That worries me. Because it is a serious indictment, number one, to the regulatory environment, to the training environment itself, and to we who earn our living in the training environment. Truly, if I earn my living in a law school, as I do, as your teachers do, as your dean does, and the product of that law school is unemployable lawyers. I'm using the word lawyers very liberally there to accommodate them because it means they're not lawyers in the first place. Then, it means I'm engaged in a scheme of fraud. I'll be defrauding your parents and other financiers, including the government. So, my verdict on this question is that the state of our profession is emerging into a paradox. We are many, but fragmented. We are trained, but not transformed. We are licensed, but not empowered. Let me reflect on the changing market. 3 aspects bother me in this field of the market: technology, clients, and competition. The market itself is changing faster than we are doing. Technology is rewriting the rules of the legal profession. In some cases, abolishing the rules. Courts now hear matters virtually. 10 years ago, 8 years ago, 6 years ago, if you had told a lawyer like me that our courts will hear matters virtually, we would have laughed you out of the room. Contracts are being drafted by software. Clients are consulting AI tools before visiting advocates' chambers. Globalization and regional integration are in the vogue. It means that a client's dispute in Eldoret may have its resolution in Arusha, and it may have its transaction in Kigali, and its financing in Lagos. As all these are happening, the public trust is waning. Many Kenyans now fear lawyers more than they fear injustice itself. If clients fear lawyers to the same level that they fear the police, and I'm not suggesting that police are supposed to be feared, then our profession will have lost its high moral ground. We must therefore, at that juncture, repose the question, are we still a noble profession, or have we just become another service industry, like taxis, by which I include border, one chasing briefs instead of building justice? Let me reflect on the broken bridge, the disconnect between training, research, and practice. I believe that our crisis is not only economic, that lawyers are unemployed or underemployed. I believe our crisis is intellectual. I ask my students in legal theory every so often, who is an intellectual? And they grapple with that idea for a while. In summary, I tell them I have no answer to that question too, but I believe of his many attributes, an intellectual must be one who is excited about ideas. Have we broken the bridge between training, research, and practice? We have been accused in universities of teaching law as if it is static. Cases, doctrine, memorized notes, instead of teaching law as a living instrument of policy, technology, and society. In our research, you write brilliant research papers, sometimes AI-aided, and they sit in journals, but no policymaker ever reads them. Why? In practice, we focus on transactions and litigation, but we spend less time reflecting on underlying systems and ideas that shape the law. The result of all this is tragic. We have research without relevance. We have practice without reflection. We teach without transforming. This must change. We must reintegrate these three pillars into the ecosystem where teaching draws from research, research serves practice, and practice informs teaching. And therefore, that cycle becomes sustainable as it regenerates. So I propose that we must revolutionize legal education from memory to mastery. In my preparation for this engagement, I had a chance to peruse the strategic plan 2023-2027 of the Council of Legal Education. If you look at that strategic plan of the Council of Legal Education, it has a vision. And the vision for that strategic plan is innovative legal professionals transforming society. I hope you know what a vision is. When the Council of Legal Education stares at the future and sees you in that future, it has a mental image of innovative legal professionals who are transforming society. I suggest in this room, this vision must become our national agenda. We must reimagine legal education along the following three lines. Number one, curriculum reform. Through curriculum reform, I suggest that we must teach law in context. We must move from subject-based teaching to problem-based learning. We must teach law and technology, law and governance, law and business, so that the focus is how the law is simply a tool of solving a societal problem. Law students must learn data science, data protection, environmental compliance, cross-border commerce as naturally as they learn constitutional interpretation. Secondly, I suggest pedagogical innovation from the lecture to what I call the laboratory. I know that many of you came to law school because you feared natural sciences, and worse still because you failed mathematics. That you asked a neighbor, I wish to join the university, but please suggest to me a course that does not require mathematics. Then they told you, Jaribu Law. And that's why we are here. I suggest that we must supplement or replace rote learning with simulation, clinical practice, policy laboratories, and community legal service. Law schools must become innovation hubs. Every law student should leave campus with not just a transcript, but a portfolio of briefs, policy papers, and prototypes, including prototype draft legislations, as the learning output. I also suggest market integration. Internships should no longer be charity. It should be co-designed between law firms and faculties. The Advocates Training Program at the Kenya School of Law must evolve to produce advocates with digital literacy, commercial awareness, and more importantly for me, ethical depth. Allow me to also suggest something I call reimagining legal research from the ivory tower to the public square. As academics, we are sometimes pejoratively accused of living in the ivory tower. It is the late Professor Onesmus Kimweli Mutungi who told me that academics have more than two hands. You ask them a simple question. They say, on the one hand, it may be this. On the other hand, it may be this. Yet on the other hand, then he asks, which one? I thought you have exhausted your two. Because you have two hands. Which is that third one? Legal research in Kenya is still too inward-looking. We publish for promotion instead of for impact. Next time you want to become a senior lecturer from a lecturer, or an associate professor from a senior lecturer, or a full professor from associate professor, we tick the box by asking how many publications. As a number, not what has the impact of your publication been. Yet, law is never meant to be admired. It's meant to be applied. Research must feed into public policy, legislative drafting, and judicial reform. The faculties of law should become think tanks for ministries, parliament, the judiciary, and civil society. I plead that let us measure research impact not by how many journals cite it, but how many statutes, how many judgments are inspired by it. We must fund joint projects between academies and practitioners. Let every major public inquiry, from data privacy to land reform, etc., have a university law firm partnership at its core. When teaching, practice, and research merge, then the profession will regain its soul. The assumption I'm making is that the academy has retained its soul. The answer to whether you still have your soul lies in you. Let me reflect briefly on the future of practice. The lawyer of the future will not fit neatly into our traditional robes. Tomorrow's advocate will be a technologist, fluent in data and in AI governance, a strategist capable of advising startups, multinationals, and states, a mediator skilled in online dispute resolution, and a public intellectual shaping policy and civic thought. Cross-border practice will become the norm, not the exception. The African lawyer of the future will not be defined by the limits of the Kenyan bar, but the scope of African integration. And as technology automates what we have hitherto had as routine work, what is it that remains of we, the lawyers? What remains of we is judgment, ethics, and wisdom. These are the only three things that technology may not be able to get into. In this age of algorithms, the last competitive advantage that we are going to have as lawyers is integrity. Because AI, I'm not sure will be able to discover how to infuse itself with that software of integrity. That remains inherently human. And that's what's going to be a competitive advantage. A good sense of ethics, a good sense of wisdom, a good sense of judgment. I make a call for courage and imagination. To the students, you are not just the future of the profession. You are the reformers of this profession. Do not define yourself by terms such as unemployment. Define yourselves by imagination. You remember Kenya's famous athlete Eliud Kipchoge says, no human is limited. To the advocates in the room, do not only take briefs, take positions. The law is not just a tool of income, but a tool for justice. To the teachers, infuse your teachings with the law as it should be, not merely the law as it is written. Into other institutions, regulate not only for compliance, but for courage. The future is not to be policed. The future is to be prepared for. In closing, let me make out a case for from survival to significance. The tragedy of the Kenyan legal profession, in my honest view, is not that it is overpopulated. I believe the tragedy is that it is underpurposed. We have been content to survive, to get admitted, to get briefs, to get by. But survival is not enough. Our challenge is to move from survival to significance. Maybe you are there asking, how will I contribute to this as a student? I have a simple proposal for you. Take your studies seriously. As a career student in my own right, I know that your primary duty as a student is to study. Your name, student. Your title, student. Your office of student derives from the word study. And therefore, if you don't study, we will not take you seriously. We may lose respect for you. Let us not ask, how do I earn a living from the law? But rather, how does the law earn a living from me? We must discover the moral imagination that built this profession into the prestigious profession that attracted us, you and me. The future of the legal profession is not ahead of us. The future of the legal profession is within us. I thank you.
Okay, once again, I would like us to request a proper round of applause for our keynote speaker this afternoon. And on the same note, may I request that we give our dean also his flowers, please. Now, despite the fact that I am not part of the legal profession, sitting here at this public lecture, I must say I have learned a few things, one or two, that I will take away with me. And I do not know about you, but one of the things that has left an imprint from this discussion for me is, as lawyers who are particularly in Daystar University, a university known for its communication out there, what are you doing in that space? You as a lawyer, what are you doing in the space of communication? Considering that the university you go to is niched in communication. So let's take that as a thinking or a thought-provoking discussion amongst ourselves. Thank you so much for gracing our presence. Thank you so much for educating us. And at this moment, I would like us to move straight into our panel discussion that will take just a brief moment. I would like to invite Ms. Stacy Minor, who is the panel's moderator, to invite her panelists. And let's give her a round of applause as she makes her way. A better round of applause is suited. Karibu sana.
Thank you so much. Good afternoon, everyone. My name is Stacy Minor. I will be your moderator for this panel session. And on behalf of the Verdict and the Daystar School of Law at large, being the host university, I am deeply honored to welcome you today to this panel session on the theme of the state and future of legal education in Kenya. I will be joined by an a truly exceptional panelist, and I will like you to help me to invite them on stage. First, we are deeply honored to have with us Professor Jack Mwimali. A round of applause, please. Professor Jack Mwimali is a scholar, a legal educator, as well as a legal practitioner in Kenya, and as has been mentioned, he is the CEO of the Council of Legal Education. Kindly, a round of applause as we welcome him on stage. Oh, I'm being informed that he has just left, but as we wait for him, we can also welcome on stage, alongside him, we will be having an exceptional law student. Her name is Nigel Agai. A round of applause for her also. She will be offering us a fresh voice on the lived experience of being a legal student in Kenya. She is part and parcel of the Verdict. She is the president of the International Court of Justice, Daystar chapter. Kindly let's welcome her on stage. Okay, in the interest of time, we will proceed as we are able to get Professor Jack Mwimali back. So for our first question, that will be directed to both our panelists, from your own view, what is the current state of legal education in Kenya today? Oh, Professor Jack is here. Kindly a round of applause as he comes on stage. Tafadhali tusichoke. This is the CEO of the Council of Legal Education. We are deeply honored to have him here. Thank you, Professor Jack, for being with us here today. We truly appreciate it, and we are deeply honored. So we had already started with the first question directed to both our panelists. And the question is, from your own perspective, what is the current legal education in Kenya today? How would you describe it? And Ms. Agai was just about to start us off.
Thank you, Stacy. To our distinguished guests, thank you for making it today. And to all the students, thank you for honoring our invite. So the current legal education system in Kenya draws its pedigree from the common law system, and it has two phases, the theoretical phase and the experimental phase. The theoretical phase is what we are currently doing, that is the degree level together with the diploma level offered at the Kenya School of Law. The experimental phase is more vocational and practical, and this can be seen through our legal and judicial practica, together with the pupillage that is done at the diploma level. There is also an increasing attention or an increasing need to adapting the legal education to new fields such as ADR, alternative dispute resolution, together with online dispute resolution, and also technology law and cybersecurity law. Yeah.
Thank you so much for that response, Professor.
I hope I'm audible. It is a bit to my shame and chagrin that I could not sit in to hear my good friend Elisha Ongoya make his presentation. I know he must have alluded to some of the things that I'll be pointing out. It's because there was a call of duty. Actually, we had a council session that I needed to attend to that I've just excused myself. It's indeed a privilege and an honor for me to join you this day for this event, which as at the Council of Legal Education deem very critical, because the future of legal education is at stake. It's at stake not because it is a hopeless cause or a lost cause, but it is because we stand at a defining moment of legal training that we must revisit. It's a challenge that us at Council are still considering. There are quite a number of issues that emerge that would require us then to rethink how we offer legal education, not just in this country, but for the region. There has been a blow-up in advancement in communication technology, which then presupposes that the practice of law would not remain in the traditional sense. There has been a question on what role would, for example, artificial intelligence take in litigation vis-a-vis the role that lawyers today play. It's a question that is yet to be answered, but already we know that there are certain things that artificial intelligence can do that then one would fear may replace the physical lawyer in some aspects. But beyond just artificial intelligence and technology, we also have issues that we have not really fully comprehended in terms of delivery of legal education. For example, have we really addressed ourselves to how we practice regarding the devolved units in the constitutional dispensation? And these are questions that we have no answer. They are still moot because it's something that we need to then address. Actually, at the moment, we are grappling with it at Council, and therefore we have, in fact, prepared. There will be a conference between the 2nd and 4th of December on the future of legal education, where all stakeholders, not just from Kenya, but from the region, will be coming to give insights, because we think the challenges are there. On the context of Kenya, as I mentioned, for example, and I'm new at Council of Legal Education because previously I was at the National Council for Law Reporting in the same capacity. And there, one of the major issues we grappled with her ladyship, the Chief Justice, was to what extent are litigators, for example, able to refer to legislation that emanate from the county assemblies? How many times have you gone to court or have you perused through case law and found reference to county legislation being the subject of court interpretation or being a subject of dispute resolution, or a context in which a dispute is being resolved? It's rare that you find that situation. Now, there are also cross-border questions and issues regarding the regulations. For example, we are moving to CBC system. Relatively, we had accustomed ourselves to regulation of legal education, to delivery of legal education courses in the context of our neighboring countries. For example, Tanzania, Uganda, at the beginning of the 844 system in the early 90s, that challenge arose because we did not know how we would fit the 844 system into the regulatory and the legal framework of the East African community so that we can continue to teach law that would be fitting for the region. Now, the same challenge arises because if we are to continue under the Advocates Act, which presupposes that practice of law will not just be limited to the country, you as budding practitioners would not just want to practice your law in Kenya, you may want to go to the East African region to practice or to international fora to practice. Are we in a position to say that we have a framework or a structure of legal delivery that speaks to those questions? Of course, beyond artificial intelligence, there are issues of cybercrime, cybersecurity, and in the international sphere, there is also a reversion back to a system where countries are now being protective. You know, the American president of America First and many other countries that are conservative in their approach to law are looking at it from almost a similar context. Do we want to protect our system so that we can only allow those who allow us to practice, or do we open it up for everybody to practice? So you are coming into the legal profession, my dear listeners, at a very critical moment where there are so many questions. In fact, where I sit, I see the questions and the answers. And therefore, when I was invited to this meeting, I thought it would be a very critical meeting because then we would start to interrogate those questions so that we see if we can address them. Sorry for talking a lot. I hope my friend Ongoya has also alluded to some of those issues.
Thank you very much for that very insightful response. And I think even as we look at the state of legal education as well as the future, it is also important to acknowledge where the evolving that the legal education has done. And so if I may pose a question to Professor, with your experience as a once upon a time law student and also in the legal academia, how far or how has the legal education evolved over the years?
I'll answer it and give an example of a scenario that I had. I think for some time from independence and then in the 70s, you know, of course, our legal system at independence, we didn't have an autonomous law school. Students would have to go to University of Dar es Salaam. Then it was just a college. And even before that, there was no University of Dar es Salaam. So we had to use solicitors and barristers who are practitioners in England. And in their system, of course, they had two-structure or two-tier practice approach. Here, we had adopted the system of an advocate being an all-rounder. We don't have solicitors, we don't have barristers. And therefore, we had to envision our system, which we did quite appropriately in the 60s. Come the 70s, you have the University of Dar es Salaam offering law, and all the East African, especially within the community then, the old community, going to Dar es Salaam. And then other countries now starting to offer law in their jurisdiction, the breakup of the East African community in 1977, and it leads to a scenario where we had to rethink and reimagine legal education, and we developed a system up to that time. My perception is that at one time we got so comfortable with the structures that we had set up for legal education in this country that we did not want to move. In fact, we looked at those who trained, say, from other jurisdictions as being a distortion of what we expected as a practice in this country. We looked at, for example, Module 2 students who are self-sponsored as being outliers and therefore not as qualified as those who are brought in as Module 1. And therefore, regulation and teaching of legal education started to have that divide of who are our students, who are our stakeholders, and that we dealt with for almost 10, 15 years. Then after 2012, I think we have paused in terms of how then we reimagine the questions, because the regulations have been to address those existing issues without now necessarily looking at what is the world shaping up into in terms of the legal system, and whether we must be able to accommodate that universal development in legal practice that then we need then to reflect on. So my feeling and my view is, for the last, and I've been in legal academy since 2008 as a lecturer, I have had the opportunity and privilege of teaching both in England, in Tanzania, in Rwanda, and here. And I have a feeling that in terms of us being creative, we lost it somewhere. We started to reimagine problems. The challenges and the questions we sought to answer was, why is legal education going down? That we are losing it. We are not reimagining that we can then regenerate, reorient the way we teach our programs. Rather, we wanted to resolve real and perceived and imaginary questions and concerns. I want to put to you that time has now emerged, that we don't just address it, because in every generation there are very good practitioners and there are very mediocre practitioners. It is not limited to any one generation. But we need now to reconceive how we look at legal education from that perspective. And I think you, as the new students, should now reimagine. For example, it was 2012, I was a lecturer at the University of Nairobi. We were rethinking on how to reformulate the curriculum. And the young lecturers then came up with a suggestion that the School of Law in its postgraduate program should not limit itself to just teaching law as law. There are people, for example, in the medical field who would want to do further studies in law to intertwine the knowledge of their medical practice with legal experience so that they can address questions of medical jurisprudence, medical negligence, and such questions. And the old professors could not hear anything about it. In fact, they walked out on us and they told us they could do that. We could only do that on their dead bodies. That was how uncomfortable they were in terms of thinking of that possibility. And of course, if you reflect now, quite a number of institutions, and University of Nairobi itself, through KESLAP, started to establish programs that are multidisciplinary. They are not just limited to the training in law. In fact, for you, I would encourage that beyond the legal studies, and even as we design curriculum for universities, beyond teaching 100% legal content, supposing we teach you 20% content on what medical students do, physiology, anatomy, so that as you go to examine medical jurisprudence cases, you are dealing with an area that you understand. If you are cross-examining a medic, if he's talking about medical issues, you are able to deal with those medical concerns. Similarly, if it's about construction and building, you have understanding of the art of architecture, the art of construction, rather than the regulation of architecture and regulation of construction. And therefore, I think it's a very good time for you to be in the legal space, because it provides an opportunity for you to think, what can I do beyond what the classical, traditional practitioners have done in that area. Thank you.
Wow. Thank you so much for that response. It was an all-rounded response, and it has brought out the issue of curriculum that I believe has been addressed by all our previous speakers. Our dean mentioned that the legal education is actually shaped by the curricula, as well as our chief guest spoke about the practicality or lack thereof of the current existing curricula. And so, directing the next question to Ms. Agai, as a law student, do you think that the current curriculum sufficiently prepares law students for the legal realities or legal practice in Kenya?
Thank you. Not entirely. I think that there is a significant gap between the theoretical learning and the practical experience that is at the fields. The pace at which the legal education is developed, the legal landscape is evolving is faster than the pace at which the curriculum is being changed. We are moving from the traditional litigation to different dispute resolution mechanisms, such as mediation, arbitration, and so forth. There is also the advent of technology that is changing so much within the legal field. The CLE strategic plan of 2023-27 itself recognized that graduates are not sufficiently prepared for contemporary and emerging fields such as cybersecurity law and electronic evidence. But I also think that the blame should not only be placed on the curriculum setters, but also on the graduates themselves. There are opportunities that are afforded to graduates to build themselves, to develop themselves, so as to prepare them for legal practice outside. But we see that students do not put themselves out there. Students do not show up for themselves. For instance, mooting activities, legal aid activities, there are very few students, if I may say, who show up for such activities. Then can we really put the blame entirely on the program setters for not being fully prepared for the legal profession once we are done? Yeah.
Oh, thank you. You have ended with a question. All right. Turning back to Professor Jack, and this is an issue that has been brought up again by our dean, and this is on the decentralization of the Kenya School of Law as the only institution offering the advocates training program. And fortunately, today we will be able to get first-hand insight from the source itself. So Professor Jack, could you offer insight on this decentralization and the importance of it or lack thereof?
Thank you for that question. Fortunately, as I said, I come for a discussion in the context that, number one, if I may just provide a brief history of the issue of decentralization. You know, for the longest time, we have had up to 1994, practitioners who went to local universities never required to go for the bar exam. They would just complete their practice at the at that time, actually, they needed to go. After completing the 3-year program at the university, you went to Kenya School of Law, where you were trained for practice, almost similar to what we have. Then about 1994, 95, they changed the system so that the Kenya School of Law would just cater for those who had come from foreign countries or those at the local universities who had opted not to do their practical courses or units in the universities before they go to pupillage. And therefore, there were few from local universities who would go to Kenya School of Law, but largely it catered for foreign students. And of course, those days, the numbers that you are talking about is between 50 and 150. Now we have a situation where I have just been doing preparation for the next bar exam. We have 1,900 candidates whom we are preparing, in excess of 1,900, to sit the exams next month. Would you say that you can, within the context of one institution, offer legal training, especially of practical nature, to that number of students? Of course, there are litigations that have gone about and court decisions that have said that part of what is required under law is for devolution of legal education. Currently, we are working on legal education regulations, both for ATP, for examination, for paralegal studies, to determine the pathways through which somebody can then join the legal profession. And in all these situations, we are actually looking to the stakeholders, yourselves. In fact, very soon, we'll be engaging law candidates to ask you, what do you think would be the most appropriate approach that would take, even as we are definitely required to develop? There are very many options that one can look at. For example, decentralization of Kenya School of Law itself, having campuses in the manner or framework that you would think of KMTC. You would have a situation where we have specialized institutions offering the ATP program, specialized in the sense that we are not coming to Daystar after you have finished your course at the end of 4 years, then you come back here to be trained for the bar training before examination. And there is also the hybrid way, so that if you have built all this infrastructure, and I'm amazed at how Daystar has gone. The last time I was here was in a graduation, I think in 2003 or 2004 for a colleague. And it was a very small institution. Now there is a large institution with immense infrastructure that have been put up. Would it be a replication, for example, to have other institutions, specialized institutions to offer by exam come up? Or do we use these facilities that are already existing? So there are quite a number of approaches that we are grappling with. At the moment, we are doing stakeholder consultation. We have had a session with the deans of schools of law. We have had a session with the CUE, Kenya National Qualification Authority. We are looking at the Judiciary Law Society of Kenya, and even the students, for us to just look at the clearer framework through which then we will devolve the training of legal education. So at the moment, I cannot for certain give you that as the Council of Legal Education have decided on a particular pathway. But rather, and the Constitution does require us to do so, we are looking at public participation and stakeholder engagement to see how best then we can deal with that problem.
Thank you very much for that response. Turning back to Ms. Agai, we cannot fail to acknowledge the role that technology is beginning to play when we speak about legal education and legal practice in general. So as a student, do you see this as a threat or an opportunity for innovation, as had been mentioned by our chief guest?
No, I do not see technology as a threat to legal education. Rather, I see resistance to technology as a threat to legal education. Technology is an opportunity to expand the legal profession and not only to transform it for the better. Traditional methods of practice, such as physical litigation, is being replaced by technological tools such as e-filing, while we are having our judicial practica, for those of us who had. We got to experience things such as virtual hearings, which were more or less, if I may say, the order of the day where I was stationed. We also had e-filing systems, such as the court tracking system, CTS, which I think made work easier compared to having to locate files physically, which myself I found rather tiring. And also digital registries and such as Ardisasa, which make registration processes quite easier for us, together with other entities such as, at the moment you can register a society or a company online. This comes quite handy in cutting the costs that you would spend in doing the entire process physically. Also, traditional methods, just an example, while I was doing my judicial practicum, we were often tasked with typing proceedings. And this, myself and those of us who had to do that would say was rather tiring, considering the timelines that we had to do this in. And having to read the proceedings that have been handwritten, and not to speak ill of our judicial officers, but their handwriting are not so far from those of a doctor. So they are quite difficult to read. So this situation could be easily solved by embracing technology. If you could have our judicial officers type these proceedings rather than handwriting them, and having someone else do that would make things easier. Also, in our day-to-day learning experiences, as a Daystar student, we have an e-learning platform where we are able to access notes, we are able to access lectures. This makes work quite easier for us. There are also other online platforms where you can get notes and use them to revise and make work. It basically makes learning easier for all of us. And sometimes we have had online lectures. Considering this weather, an online lecture would be quite advantageous to some of us. Yeah, thank you.
Thank you so much, Ms. Agai, for your insights. And finally, before we open the floor to any questions, Professor, what is your hope for the future of legal education and the legal profession in Kenya, perhaps in the next few decades?
When I was invited for this event, I didn't even know, but I purposed to come. I think when you contacted me, you had my response, even before I understood. And I'm saying this because I see you as the future of legal education, the legal profession, and the practice of law in this country. I think we have done our bit. I think every generation has its own challenges that needs to be addressed in the context of what they feel. The way you operate, especially the Gen Z generation, is not the way we did operate. At least some of us had the opportunity of intersecting. I remember the first time I went into a law firm, not a law firm really, but a legal entity where I was practicing. We went for a meeting. I was asked to be the responsible person to take minutes. And I sat with my pen and paper. That was in 2003, and wrote my minutes and put them somewhere. But I didn't even take a lot of attention. They had not actually asked me, but they expected that since I am there, I should have actually captured what happened. So I captured 2 or 3 notes and went. And then the next day I was asked, where are the minutes for the meeting? I had not captured everything fully. And you can imagine the ability of the human mind to think. I rethought through what had occurred throughout that meeting, produced comprehensive minutes, but in handwritten form, and I submitted it. And I was told, are you a joke? What is this? I said, these are the minutes. He said, in this age and time, you can't have handwritten minutes. Go and type. And you can imagine myself with one finger tapping at the keyboard, trying to come up with the minutes. That's not the time you are living in. In fact, we have gone beyond now you typing. You can speak into these machines. And even now, you know, they have learned to understand our accents. When I was teaching at England, one of the students' comment at the end of the semester was that I had a very strong Kenyan accent for a Monday morning. And the other challenge that I had was every time I wanted to transact, because they had online transaction that you just needed to speak to the phone or computer, and then it gives you the information. So say repeat the phone number, and then I'd say 0, 1, 7, and so on, and then the machine would respond back to me, I can't understand, please repeat. And therefore, I was not even able to do that. Right now, the technology is such that you can just listen to, even the way you speak, with however heavy an accent you have, it would be able to transcribe. But now that creates another challenge. Because as a lecturer, you send out students to do an assignment. They go and obtain documents, especially at research level, from ChatGPT and other artificial intelligence infrastructure that is available, and they submit to you that this is the work that I have done. And you know, in fact, AI is continuing to evolve, so that the classical initial way of identifying that this is not this student's work is no longer the case. Now, it may almost appear that it is the student who has done it. So how do you deal then with that when you are teaching? The end that I have come to conclude is that we must accommodate that because it's there with us. And there will be even more technological advancement. So in the recent past, what I have been doing, and for you, if you become my student, I would tell you, I see you have written a very good paper. I would bring out some few issues that outside the scope of what you have written. And then I would ask you, have you thought about this? Could you also try and include this and include that? If you have just gotten it from ChatGPT, it will take you aback, isn't it? You'll bring me another set of papers because you have fed the machine. It will not accommodate what I have done, or if it does, it will then take you away from what you had submitted. So I would come, or if you come back to me, I would say, but this is not the paper that you submitted in the first instance. I had just told you to review and include. So you see, we can still interact, we can still learn, even in the context of the infrastructure that has now emerged and exists in legal education. In fact, these days I tell students, take opportunity and take advantage of all these. You know, you don't have to go to the physical library daily the way we used to do to get this information. Don't make it hard for yourself. Don't read hard, read smart. But even as you read smart, ensure that you inculcate your ability, your knowledge, your desire to learn into the output of what you're going to, so that that information should not just be generated from the internet. Own it. Have it in a way that it would speak to what you as an individual think. AI can generate something for you, but you need to have customization and ownership so that you don't have to do it from scratch, but you have to put your intellectual input into it.
Thank you. Thank you so much, Professor. With that, I believe the future of legal education is indeed bright. And thank you so much, the audience, for listening. That marks the end of our panel discussion. And thank you, our panelists. I believe you have given us a blend of experience, intellect, as well as lived realities. So I will hand over back to the MC to receive 2 questions for this panel discussion. Thank you.
Okay, like Ms. Stacy has mentioned, we will be taking 2 questions to our panel at this juncture. Anyone with a question towards our panel? Just 2, that's 1. Another one?
Thank you so much. My name is Alex from the Mount Kenya University School of Law. My question is on career progression. I know Mr. Elisha Ongoya has spoken about passion, and some of us have passion to one day become an advocate of the High Court of Kenya, and we really want to bring change in our profession. And we have paid all the price even to become that which we have passion for. So how can we then be accommodated in this profession? Thank you so much.
We will take 1 more question. Anyone? Sawa, we'll have our panel respond to the 1 question as we move forward. Sorry.
Professor, I think that was directed to you.
I think more than 50% of success in legal education is that passion. I have always mused. I was never the best student in my elementary and high school education. I just sat and I was somewhere there. I was able to do 1 or 2 things. I was never number 1 or number 2. I would be there. And yet, I had a very clear mind that I wanted to be an advocate from when I was in Standard 4. I was very clear that I wanted to be an advocate. In fact, to the extent that when I was doing my Form 4 exams, I pre-planned that sciences are a waste of time, and therefore I would not venture into them. The last time I interacted with physics was when we were doing a concept that revolved around an Avogadro's number, and that lost me completely. And I said, even if I get a D in physics and I plan myself to get good grades in these areas, then I would be able to meet my desire. And with that passion, I was able to actually actualize my, and I'm not telling you to drop off and do stupid things that I did. Looking back, I could have done better, and it cost me a number of years to get to achieve my intended aim because of that approach that I took. But the fact that I had passion for it got me to be a lawyer, as I had wanted. But number two, just being a lawyer with passion is not sufficient. I've told you we are going to be examining 1,900 students. In December, on 26th of November, we have an admission to the bar of 921 students. When I was admitted, we were only about 6,000 lawyers in the country, and even then, we thought that we were so many. Right now, there are more than 25,000. Being a lawyer will not get you across the line. You need then to move beyond just that passion. And I think if you derive the passion, combine it with some wisdom and introspection and hard work, then you will be able to achieve what you desire, even as you develop with the passion that you have said. So the passion will take you about 50% or even 60%, but now you have to add into it. There are scriptures I read. They say to your love add, to your add. So if you can add something to just being what you are, and I have always encouraged students, you may even think of something, that is outside the legal practice. Journalism, writing, IT, just computer work. As a lawyer, beyond, there's that lawyer in, was it Eldoret, who was a carpenter? Do something just beyond, when the law has been saturated in your head, what else can you do? I think that would then help. Thank you.
Thank you so much. I think that suffices for a response. And thank you once more. You have been a wonderful audience. My name is Stacey Minor. I have been your moderator. And thank you to our panelists for the exceptionally rich and timely conversations. That will be all from us. Thank you.
Sawa, let's give them a hearty round of applause. Thank you so much. And I believe at this juncture, no one has been left out. Should you have a question to pose to our keynote speaker, this will be the time. Anyone with a question to pose to our keynote speaker from his address, something that you would want to know more about, this is your opportunity. We will only take, as per the earlier, 2 questions only. At the same time, we will be inviting our keynote speaker to respond to these questions as he gives us his remarks on the verdict as we are moving smoothly towards the end of our activities this afternoon. I will pick a question from that side and here, and those are our 2 questions.
Everyone. I am Mudhuri Mudhali. Unfortunately, our institution was not recognized at the beginning. I'm from JKUAT Law School. And my question is about, you talked a lot about reigniting the passion. In fact, I think the word you used was moral curiosity. And we also have this conversation of having young lawyers, students, and generally legal practitioners coming into the policy space and thinking and coming up with solutions. We have law coming from a background of philosophy, asking big questions about how things are, society is. So how can we have that at a time in Kenya and in Africa broadly? We really have questions that need to be answered from a Kenyan perspective, from an African perspective, political questions, sociological questions. How do we have that? How do we make institutions of learning, of legal learning, places of critical thought to shape Africa's future? Yeah.
Thank you. My tradition is always to answer one question at a time so that I don't gloss over anyone's question. Your question is broad. It's a question of how. And truth is, there's no one cure-it-all method of doing it. There's a multiplicity of methods whose end result would be that. Let me give you just a few examples. There's an interview that was done a day or two ago. Those of you who follow South African politics may know one of the top officials of Malema's party, the Economic Freedom Fighters. That top official is called Mbuyiseni Ndlozi. And he has introduced a new podcast called African Renaissance. And the first edition of that podcast, he was interviewing the second president of South Africa called Thabo Mbeki, himself an organic intellectual. And one of the greatest troubles they identified, and which I identify with, is we are losing our history. And if you don't know where you are coming from, chances are you wouldn't know you're going to. I have reflected on a number of simple and straightforward questions. For example, as I was listening to the podcast, I was playing it in my car, I was driving in the morning with a Gen Z niece. And I sought to know from her, who is that speaking? And she struggled first to identify who it was that is speaking. We eventually built the consensus, that is Thabo Mbeki. And who is that? He said, I have just heard of that name. I honestly have no detail of who that is. And it pained me. It pained me because to the extent that Africa has suffered a leadership crisis over its post-independence history, some of the leaders who have given us a glimmer of hope would include Thabo Mbeki. And therefore, to imagine that there is a young African intellectual, a university graduate, who does not know who Thabo Mbeki is, it pains. So one of the things I struggle with is not whether we should teach in class, but whether we should have small cell group intellectual conversations among learners where we learn African history, proper, organic African history. I was in Zambia not long ago, and I was going to visit friends in a town called Ndola. And when I landed at a place called Ndola, I landed at an airport called Kapwepwe International Airport. And I struggled, and who is Kapwepwe? I was seeing that name for the first time myself. I had never heard of such a name in my lifetime. I learned later that was the first Minister of Foreign Affairs of Zambia. Where did this history disappear to? How come we don't know it? A part of the solution is just reigniting a study of our own history. Who are we as a people? Because one of the reasons why we do not have a lot of organic intellectualism in Africa is because we don't even know ourselves. We have lost our identity. We have lost our history. We are accused of regurgitating what others have done. That is a natural and logical consequence of submitting yourself to studying other people's histories, other people's intellectuals. You can't be part of its creation. You can only wait for them to create, then you replay. And therefore, just to answer a part of your question is, what can we do about our university curricula and our university models of study where our learners have opportunities to reflect on African ideas, African histories, African personalities, African arts, African cultures? That way, we are able to rediscover ourselves, and we are able to build our own homegrown knowledge. Because, like it or hate it, in today's world, if you are not part of knowledge creation, you will be overridden by others. Others will run roughshod on you. There's no formula out of that until you begin creating your own ideas. So that on the market, in the marketplace of ideas, they arrive with their ideas and you arrive with your ideas, and therefore you are exchanging ideas. Otherwise, you remain a net recipient of ideas, in which case, as Kibaki will put it, when bure kabisa. When you are a net recipient of ideas, you are completely of no use to others. It's only those who create ideas who are of some use. And therefore, to our academy, Daystar University included, how much of our university experience entails meeting under umbrellas? You know that place where they sell snacks and soda? How much time do we spend there just engaging with ideas as opposed to being on Facebook or Twitter or other places? How much time is spent there just on ideas? At Kabarak University, where I teach, there's something you may have heard of called the Avid Readers Forum. As I'm here today, the Avid Readers at Kabarak are meeting at the Avid Readers room. We now have been allocated a room at Kabarak, where you just meet and discuss ideas of Michere Mugo, ideas of Ngogi wa Thiong'o, and so forth. Now, make no mistake about it, they don't attract the masses. You'll hardly find 15 people there. Others have better things to do with their busy time, which is being on Instagram and looking at the hottest tea at the marketplace of teas to be able to follow. That's the reality of our life. Somebody spoke here a very piercing reality that the CEO. CEO tells us, let's change our teaching methods. And we are now working towards incorporating the competence-based education at the university level. And how shall that be? I'm trying to imagine the lecture method of teaching is going to be abolished, and we are going to have practical methods of teaching where learners are co-creators of knowledge, where we are going to have moot courts, and we are going to have debates, and we are going to have how many learners at Daystar University participate in moot courts at this age in history? Ni miujiza gani hiyo itatendeka next year when CBE reaches as of 5 years from now, that will now become vociferous adherents of moot court participation? We need to reorient our thinking. We need to rediscover ourselves. And I keep telling my learners, you must wake up tomorrow a new person. You must say from this morning, hata hapa Daystar watu watajua nimebadilika. They will see me and see an intellectual. And there's no shortcut to that. And hope in itself is not a method of doing anything. Don't hope that one day you just become an intellectual. Begin working towards intellectualism from tomorrow. Thabo Mbeki has suggested some of these ideas in his famous lecture at Stellenbosch University, where he says, at least familiarize yourself with the instruments of the East African community. Familiarize yourself with the instruments of the African Union. Familiarize yourself with the instruments of COMESA, of ECOWAS. Begin knowing your continent, your space, its personalities, and their contributions, so that you are a proud African. I think if we do that, chances are, in another 5 years, 10 years, 20 years, we will look at our university schools and say, we think that passion is being reignited. In the absence of that, we will meet here 20 years from now to lament, as we are doing today. The second question? Where is the microphone?
Yes, my name is John Koech. I would like to inquire a question on behalf of law students at Daystar University. I'm aware that you are a law lecturer at Kabarak University. So we have a challenge here at Daystar University. And I know that our lecturers wouldn't wish to hear or listen about this. And that is the same if in case it happens at Kabarak University. So this as well goes to the Council for Legal Education, that we have law students at all Kenyan universities who need to do their legal practicum or their that is sort of attachment, if I can say so. Law firms. Now, when it gets to doing legal practicum, law students, not only in Daystar, but all other universities, have a challenge of acquiring a position to conduct their attachment. Now, through the Law Society of Kenya, why can't you be compelled to at least accommodate law students from all Kenyan universities so that we don't have difficulties in acquiring attachment? Why should we always apply?
Thank you. Thank you. That's a very popular opinion. That's a very popular opinion. And you are right. You are right. You are right, because if, for example, the university at Daystar came up with a policy that for me to get my PhD from Daystar, I must have at least 3 peer-reviewed articles in journals, and Daystar does not run a journal, where does it want me to publish? That's a legitimate question, isn't it? If we make our graduation subject to a mandatory practicum attachment in a law firm, and there are no law firms offering us attachment, then that is expecting conduct of us or of you as a student that is beyond your capacity, which is unfair. I agree with you entirely, and therefore that's what I'm saying. Your question is popular because it touches all of us. And let me just give a third example. You know, many years ago, I began offering attachment to students the moment I became eligible to offer attachments. The moment I clicked 5 years in legal practice, the law requires that to offer pupillage, for example, to Kenya School of Law students, you must be at least 5 years in practice. I began offering pupillage to students. And the problem will shift. The problem will now not be whether you offer them pupillage or not. The problem will be how much are you paying them and where are you underpaying them? When you begin paying them better, again, the problem shifts. So problems have a way of mutating, but that's the nature of life and nature of human beings. So one day I remember in my pioneer students, the very first ones I took on board, of course their grievances were about pay, and there's something about time that is very exciting. Time is a very interesting phenomenon. A few years ago, when Kabarak University, in 2013, Kabarak University was doing its 10th anniversary after the first graduation class in the law school. The very first group to graduate from Kabarak University School of Law was in 2013. So in 2023, we were marking 10 years. And fortunately, because we only had a class of 6 students in the first class, I organized a lunch for all of them. It's easy, it's cheap, it's affordable. You only have 6 graduates. So we were reflecting on their journey 10 years later. So I hosted them for lunch 10 years later, and we were reflecting on life. We sat up to midnight. We sat from 9 in the morning up to midnight. No one saw how time ran by. And in the course of those reflections, one of those students was among those who complained most loudly about being underpaid. Now he's a lawyer, 10 years in practice. I sought to know, it is now, no, he was 8 years in practice. He had graduated 10 years earlier, was 8 years in practice. I sought to know how much he was now paying his pupils. And he didn't want to engage in that conversation. And I told him, you know, why I allowed time to run its course is because the only prophecy, the only medicine for prophecy, the only test for prophecy is time. Time demands whether a prophecy was right or wrong. And one of the things I told the learners at that life is that life is not academic. Life is real. And there are a number of things. For example, I keep reminding students that as you sit here, their lawyers are not few who borrow money from their relatives to pay rent for their law firms. Their law firms are not generating enough money to pay rent, so they are borrowing. They go to their sisters who are primary school teachers and say, lend me some money for me to be able to pay rent. And they occupy some space somewhere. So even the Council of Legal Education knows, and the CLE knows, that for you to allow, for a law firm to offer a student practical attachment, it should not just be ticking the box that the learner attended practical attachment, the law firm must have capacity to offer the attachment and impact that student. Otherwise, there are a few criminals in legal practice, and we don't want our learners attached to criminals. There are law firms who are being prosecuted for their criminal conduct in the name of legal practice. You know that? I don't want Daystar University students to be attached to criminals who became lawyers. I want Daystar University to be attached to credible law firms that can offer them a practical, credible opportunity for learning. And therefore, whereas your proposal is laudable and plausible, we need to go through all these factors. Number one, what is the capacity of that law firm? Does it even have a place where the learner can sit? Because if you came to my law firm and there's no place to sit, are you going to work while standing throughout the day? So that is an assessment that we must go through. Does it even have work? You know, you can open a law firm and don't get any work. So the fact that I have a law firm with Ongoya advocate and there's no work and you come there for attachment, so what are you doing there? The attachment is supposed to entail you doing something, isn't it? If we are drafting pleadings, then you are part of the drafting and you are learning drafting. If we are appearing in court, you are also with me in court, and so forth and so on. Once you apply that criteria, I am saying almost 40% of the people you are calling law firms will not be eligible to offer you practical attachment of their own accord. They will just not be eligible. You then remain with a smaller number to be able to deal with it. Now, if you look at the population of law students in this country, at every level, first years, second years, third years, fourth years, every level has approximately 3,000 learners, every level. We are graduating approximately 3,000 law graduates every year, meaning at every level of learning, there's about 3,000 learners. So that if you have 3,000 learners at a particular level seeking practicum attachment, are there 3,000 desks available in law firms in the country to offer you that practical attachment? When we tell you that there are 25,000 lawyers in this country, where you are offered attachment is not to the lawyer, it is to the firm, it's to the office. And therefore, the number of firms become very limited, but the number of firms with the capacity become even more limited. I know for a fact that there are members of this profession who are committed against multiple odds to continuously offer attachment. Speaking for myself, there is no point in time when there are no students in my chambers. At every point in time, including today, there are students from various law schools in my chamber. We do that as a commitment to the profession. Some of you, given that chance, commit grave sins in those firms. Grave sins. I have been a victim of grave sins from students. The incentives to give up are many, but I remind myself that is the price I have to pay for the continued growth of this profession, and to that extent, we continue to do it. When I was putting in my application for the conferment of the rank of senior counsel, one of the areas where I had enough literature to put was mentorship. Because by virtue of offering these opportunities, we are documenting them and they are part of our mentorship portfolio. And therefore, that application speaks volumes of what I've done in that area called mentorship. So yes, there is need. This is a challenge that must continually be addressed. It's unfair to the students. It's unfair to the students. Sometimes I get very many applications. If you came to my office and at every point in time I only have 3 vacancies for practicum attachment, and I have 50 applications, and this is the truth, I'm not hypothesizing. 50 applications, I can only pick 3 and leave another 47 to try their chance elsewhere, including in those spaces I've told you which have no capacity. That's how this reality plays out. So that if you are among the 47 I've left out, you legitimately can be angry with me. Why did I leave you out? But once you sit in my shoes, you'll understand I left you out because some 3 got that chance. And giving you that chance means knocking out one of these 3. The moment you begin thinking that so-and-so should have been knocked out for me, you become a bad-hearted person. you become mtu wa roho mbaya. It's just fair to understand, maybe it was not my day, maybe fate had it that way, maybe God's plan had it that way. But I agree with you that there is need for us to do more. And you'll see that even when you may not know it as students, your dean knows this. All of you go through judicial attachment at some point in time, isn't it? Your dean writes to the registrar of the judiciary and says, no, we are full. Other law schools have taken up, so you postpone yours. There are many of you who are supposed to do your judicial attachment in second year, you do it in third year. It's because they didn't write, so no, we can't take your students. All our court sessions are full. Kabarak is here, Strathmore is here, Quare is here, and therefore we are full. This is the reality. If you told the chief registrar of the judiciary, we don't care, you give us a place, it's okay. He may say you arrive, then you arrive and discover there's no opportunity for you to learn because the place is actually full and crowded, and learning requires an environment conducive for learning. An overcrowded environment is not conducive for learning. I'm making out a case that there is a context, a reality in which your problem manifests itself, but I'm also making out a case that I am aware that there is a critical mass of lawyers who have committed themselves to offer opportunities to law students optimally. Unfortunately, their optimum capacity is not good enough to accommodate all of us. It is still work in progress. I hope I've communicated. Thank you. I trust I had 2 questions. Where a third one? Okay.
Okay. Okay, thank you once again very much to Mr. Elisha for answering those questions that have been posed. Now, in accordance with long-standing Daystar tradition, we award our guests for just an appreciation to say thank you for honoring our presence. Thank you for honoring our invite as well. So at this juncture, I would like to invite CM to give our token of appreciation to Mr. Elisha Ongoya. We can have our media team on the pictures. And right after that, I would like to request our Dean, Dr. Awor, to also come up on stage to present an award to our second guest, Professor Jack Mwimali.
I am a public servant, and therefore there are rules and regulations related to gifts. So I don't know, Dean, if I would be able to receive or if I would not be able to receive. That's what I was asking.
Sawa. Thank you so much. And once again to our guest speakers this afternoon, we appreciate your presence. Now, our keynote speaker would like to give us just brief remarks on what he perceives the verdict to do, what he perceives the verdict to be within this institution and among the students present here. Welcome once again, Mr. Elisha Ongoya.
Thank you so much. I just have 2 minutes to do this because I have to leave. I have a virtual class with Kabarak University School of Law, and that one is contractual. It can attract punitive sanctions if I don't comply. And therefore, I saw this opportunity to do this, then I will be leaving after this. So if you see me leaving, just understand that is the context. First, I was very pleased to be invited to this occasion. I know with your student leaders coordinating the verdict, we have been having a back and forth conversation that culminated into my confirmation to come here today. And I thank God I have honored this invite. I try the much I can to honor invites from students because we have a moral duty to teach them good manners, even if we are bad-mannered elsewhere. We have a moral duty to put on our best mentorship armor when we are dealing with the students. Because we must lead by the power of example. And if we don't, the students will not stop learning. No, they'll just learn bad manners. Learning is continuous. It's just what they are learning that is critical for me. Your director will confirm to you when I told him that I'll be here by midday on the dot I was here. Because another thing that I teach students is just something called timekeeping and time management. One of the most precious resources that is most abused in our society is just time. That once you manage your time properly, chances are that a bulk of these challenges you're thinking about will just begin disappearing by themselves. The third thing, and maybe I mentioned this in passing, Dean, I need to emphasize it, is that I've told you, I interact with students every day in my life because, number one, I teach at the university where there are students. I offer students internships in chambers where I deal with them every day. Since I opened my law firm, there has never been a time when I have no student or students in my chamber. At every point in time, there are students in my chambers. And I have observed behavioral patterns of students over the years, and therefore, these comments I make are informed not by a one-off episodic occurrence, nor by a pattern of behavior that I have observed. I don't know how many of you have gotten a chance to intern in any environment, a law firm, an NGO, a government agency, anyone who has ever had an attachment in any institution, business. Just carry up your hand with the courage of your conviction. Thank you. I don't know what reputation you left there. I don't know. I don't want an answer. But reputation is very important for the following reasons. If I admit you in my firm as a Daystar University law student and you misbehave, chances are I will say, our Daystar chana now. Next time somebody else applies from Daystar, that person who does not know me and has never wronged me becomes disadvantaged because of your behavior. And therefore, regard yourself as a trustee for the name Daystar University. You hold that name in trust. Regard yourself as a trustee because your behavior may affect others. Oftentimes, there are things we were taught. And remember, you may be Gen Zs, and there may be Gen Xs, and there may be Gen Ys, or Gen God knows what. But the truth of the matter is that there is a core of values that cut across all these generations. And once you lack those values, your life is damaged irreparably, and the only repair is to regain those values. Trust me on that one. So don't tell me that those things you are telling me are for other generations. Our value system is theft, and we shall survive with that value called theft. No, you'll not survive, you will die. Because we eventually kill thieves. Some of them we kill them fast, others we kill them slowly, but all of them we kill them. That's how society is wired. So, some of the things I have picked from learners are, number one, a learner wakes up and informs you that I'll not be coming to work today. I've finished. I say, we have planned our week with you in mind. There's a way we have planned the work with you in mind. You can't, why didn't you tell me last week or yesterday? Or they write a notice, I wish to give you notice that I will be terminating my internship with the effect from 28th of October, 2025. It looked like a notice, and you discover that no, 28th is today. So actually you're giving me a notice that you're terminating yourself from today. That is a very common behavior among your age mates, your generation of students. And it's depressing because, why are you doing that? And so forth. And then they are just thankless people. A learner walks into your chamber, is doing pupillage, comes and cries to you, the person who was paying my fees at Daystar was my uncle, now my uncle was retrenched, now I'm going to Kenya School of Law, I have no hope. So you look at them and say, they are saying they have no hope. Okay, my firm is going to write for you some check to the Kenya School of Law to pay. They can't even say thank you. This word thank you is a value that transcends generations. None of us is at peace relating to thankless creatures. None of us. It's simple things that count for something. Keeping time. Unajua, wacha niongee Kiswahili, mwenye alikuwa anakili haya maneno anaweza switch off video kidogo tu, kwa mambo ambayo nataka kuongea. Ukweli ni kwamba wewe does not have thieves. There was a learner, not recently, a long time ago, who was given money to go and send a document by courier. He told, go to G4S and send this document. Not much money, 200 shillings. Go and send the document. He comes back and says, I've sent the document. The recipient has not received the document. How courier service works is that you must give me the way bill number so that we send it, so that the other person can check from the other side. There's nothing. What happened? Alipewa 200 akaweka kwa mfuko akakula lunch. Your document penye aliweka najua peke yake. I mean, this kind of behavior is extremely irritating, and you must avoid it as part of your growth as a well-mannered professional. I am very encouraged by the ideas behind the verdict. As I understand it, this is supposed to be a platform, a forum where we can coalesce all law students and possibly have industry players come together and share ideas. Once we share these ideas, we can get this kind of feedback that we are getting from you, and when we meet as industry, we can give feedback and say, we are interacting with the law students, and this is where the shoe is pinching them. That way, there's an opportunity of what you see today as a challenge being resolved, and we having a better tomorrow. I am extremely proud of you, those of you who thought of and have begun implementing this idea. I want to make my personal commitment that subject to you giving me good notice, because when this becomes an annual event, which is what I understand to be, then you have an opportunity to give good notice. I want to commit that so long as I am invited to the platform, to the verdict events, I will always be available unless I'm dead. So the only thing you need to pray is that I don't die, because if I die, I am not going to be available. But even if I'm sick in hospital, I can always negotiate with my doctor and make it here and see how to live early. The idea is an idea whose time has come. I said before and I repeat it here. So long as you are creating ideas, you are meant for tomorrow. The only day you will be a disaster in the waiting for tomorrow is the day you stop creating ideas. And for me, even the thinking around the verdict is symptomatic of people who are creating ideas. A quarter a century ago, there were only 2 law schools in this country. 50 years ago, there was only 1 law school in this country. Only 1. And therefore, so long as you are in that law school, you are meeting all law students in this country. Today, the number is between 20 and 25. How many law schools do we have? Yes. Is surviving there, looking at accreditation. So the number is between 20 and 27. I told you. And the rest of us have not thought about how do we create a platform where this 27 can coalesce. You have thought about it. I mean, that's you must be very proud of yourselves. That's extremely encouraging that there are young people in these universities who are thinking of tomorrow, who are saying, we have between 20 and 27 law schools in this country offering the same product producing lawyers, how would we create a platform where they can all coalesce and put their heads together on how to make the profession, the industry, better? I am extremely proud of you. If you continue doing this, we shall start speaking positively of Daystar Law School with effect from tomorrow. When you go out there, we shall tell others, be careful. Those people are no joke. Their thinking is at a new level. And for those of you who are sitting here, and you have not been part of that thinking, not all is lost. Just look for these leaders and tell them, how do I become part of that thinking? And supply your thoughts, however inferior they may be. One day, they'll just graduate into superior thoughts. Thank you so much, and God bless you abundantly.
Na ningependa tumpe makofi ya kilo, makofi ya moi. Manake substance has been spoken here. Clearly we are Gen Zs, manake that is not makofi ya moi. Iyo si makofi ya moi, we are Gen Zs. Makofi ya moi are 3-tiered claps, so let's start. 1, 2, 3 for 3 rounds. Let's go. Aya, ulikuwa umezuba. Thank you very much. Thank you very much. Now, to reiterate what our speakers have spoken on this stage will take about double the time they took to speak to us. So I believe that from our positions as the audience, we are walking away from this meeting with something of substance, something that will impact us enough to inspire action. Let us not leave just thinking we have had great things, but we have not been triggered to do great things. So let's be triggered to do great things. And as Mr. Elisha has spoken in his closing, he has mentioned that the verdict is a forum that brings together law students, law professionals to share ideas and to just talk in depth about law as a profession, law as a practice, law even as a course. So right now, I would like to ask our media team to prepare the video that we will be introducing to us exactly what the verdict is, because I believe other than this being a public lecture, as you came, you were aware that this was also partly the launch of the verdict. So our media team will be presenting to us a video that will give us insight into what the verdict as a team does, to what the verdict as a forum is meant to do, what it is meant to purpose in our circles as law professionals. And as they prepare that, right after that video, we will be inviting Coloness Munyeku, who will be giving us more insight into what the verdict will be handling as a forum for law students and law professionals.
From the lecture halls, to the chambers, to the nation's courts, pursuing an LLB starts with a calling, and yet that calling is cracked. Kenya is a home to thousands of law students, and yet there is limited mentorship. There is fragmented mentorship, and the gap between the practice and the academia, it's so visible.
Every generation inherits a responsibility to build and nurture. That is why the verdict is born, not just as an organization, but a national platform for recognition, mentorship, and meaningful engagement, where young legal minds are not only seen, but acknowledged, not only guided, but empowered. My name is Elsie Jabet, Deputy Director, and we are a convener of voices, the bridge between knowledge and practice.
We deal with matters law. We are founded in truth and principle, not trend, because when the law leads, the verdict stands.
The verdict is not just to be heard and seen, it is to be felt, it is to be understood.
Every segment you experience, every guest you see, every theme you see is a product of this department that is carefully curated to spark conversations and challenge perspectives. For every event made by the verdict, we promise that you can expect individuals who are thought leaders, disruptors, and voices that lead national and legal conversations.
And as the Legal Awards Department, our mission is simple: to shine the spotlight on the brilliant minds in the legal field. We honor those who go beyond the ordinary, individuals who lead, inspire, and redefine the position of justice in the society. Every nomination, every recognition is a story of hard work, resilience, and passion of the law.
The law is not all about statutes and cases. It's about people, it's about impact, it's about connection and networking. As the verdict, we are redefining what it means to be a legal professional. We are creating for you a space where you can network and grow in your particular profession. As the experience and engagement team, we make sure that you not only attend, it's not only a networking event, it's an experience. We're making sure you learn, you belong, and you grow. The verdict, where every handshake is a door and every story is a bridge.
We therefore call every young law scholar, every lawyer, magistrate, judges, and advocates, and everyone who is interested to grow the legal profession in Kenya to join us. Let's create a platform that upscales and serves us all. Welcome to the verdict. The verdict is in, so are we.
To our media team, the verdict is indeed in, and so are we. Let us put our hands together as we invite Colinus, the man behind the idea.